Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about a business that is formed between three brothers in the 1950s. And in essence, what happens is these three brothers come together. The business initially has a couple of incarnations. There's a fabric shop, there's some deliveries being done, there's some property bought in the inner west of Sydney, and what is alleged is that this property, now if we flash forward from the 1950s to 2018, is we're saying today we ought to divide up this property between the three brothers or their families and their estates, and we ought to figure things out. Now, the reason this became an issue is that from the 1950s and onward, the group that came to operate this business became increasingly valuable over the years and became increasingly complex over the years. And in essence, what it became was a business that owned land, that developed land, and that sometimes was a land bank, so holding on to pieces of land to later sell, and sometimes sold completed developments, and probably other times, although I don't directly recall from the evidence, rented out occasionally elements of the land that had been developed. Now, the relevant issue for us is that over time, the affairs of the group were managed by the three brothers themselves, and they were reasonably informal. But what they were not informal about was making sure the group was structured in a tax-effective way. And what that meant was that as the group grew and as new developments were found and engaged with, what would happen is that very often a new entity would be incorporated, and that would be a trustee entity, and that entity would take responsibility for developing Smith Street or Blogg Street or whatever. And so over time, what you have is this group that becomes increasingly complex with more moving parts in it, managing this really quite serious and big property portfolio. So when we say a group, we're talking about a bunch of serious number of companies, many of whom are trustees. And in essence, what we have as time passes, sadly, is a breakdown in the relationship between each of the three brothers. So the groups run between the three brothers, but they over time come to be two separate offices where things are run from, and separate brothers will take responsibility for separate things, but the relationship of trust between them starts to decay over time. Part of that relates to a parcel of land in southwestern Sydney where the ownership of it is sort of disputed. Does it belong to just one brother for his own residence, or does it belong to the group? That's an area of dispute. There are also intergenerational issues where the children of the three brothers come in to take quite senior roles within the various companies in the group. And as those children begin to take these senior roles, there are tensions that escalate, including how are we going to run this group, who's responsible for what decisions are good ones, what decisions are bad ones. So over time, sadly, this relationship of trust decays, and we have the death of one of the brothers in about 2017. Now today, our plaintiff comes before the court to seek those orders I referred to before. The orders essentially are, hey, I want to take the group's assets, divide them in three equal bits, one bit each brother, or one bit each brother's family, or each brother's executor, or each brother's interest, and essentially go our separate ways. Now, we're going to get a bit fiddly and technical because I'm going to talk about the causes of action that the plaintiff wanted to engage with. There were two broad reasons that the plaintiff said, hey court, you should do this, you should divide this thing in three on the basis I want. Basis one was that the plaintiff alleged that the group was a partnership, and a partnership in a technical legal sense. Firstly, the plaintiff said, hey look, there was an oral contract in the late 1950s the three of us made between ourselves. That oral contract was a partnership agreement, and so the various rights and obligations that legally attach to partners attached as a result of that oral agreement. That argument didn't go particularly far, and so the plaintiff then sort of made an additional argument that essentially said, well, this is what we might call an overarching partnership. This group is a property holding bunch of stuff that is operated by us as three brothers. We share profits between us. Those are features of a partnership, and because this group has the features of a partnership, it should be found to be a partnership. Now, that might have some superficial appeal to those of us who have some enjoyment of thinking about things like partnership law, but what the court found was no, it was not an overarching partnership. And the reason the court found that is because the assets in the group were assets that were held on trust by each of the companies in the group in their capacity as trustees. Now, if your brain fell out of your head as I said that just now, let's just repeat it once more. We have assets in the group. Let's say they're all pieces of land, just for the sake of simplicity. Those pieces of land are owned by companies, and those companies hold those pieces of land in the capacity as trustees for the benefit of beneficiaries, and there are trust deeds in relation to those trusts in place that say Company A is trustee of the Company A Trust and can make distributions of income and capital pursuant to the trust deed for the Company A Trust. Now, what I'd like in your head to understand is that meant that the assets, the real wealth of the group is held subject to these trusts, Trust A, B, C, D, E, F, G. And what that meant was that the assets were not partnership assets, because while a partnership can be the beneficiary of a trust, it was explicit that the assets themselves were not owned by the partnership in its capacity as a partnership. And the court took comfort in its view by sort of running the hypothetical to say, like, all right, well, if it is a partnership, let's say for the sake of argument, we appointed a receiver to the assets of the partnership. Well, that's sort of the end of the exercise, because there are no assets in the partnership for that appointment of a receiver to attach to, because all of those assets are subject to various trusts. And so the court sort of did that hypothetical exercise to take confidence in its view that there was not an oral contract partnership and there was not an overarching partnership. What the plaintiff went on to argue was that it was just and equitable that the group be wound up, and be wound up on the basis that the plaintiff argued for. Now, broadly speaking, the plaintiff sought for the just and equitable wind-up pursuant to section 461, subsection 1, lowercase k of the Corporations Act. But as I've said before, a lot of the little entities in the group, or little elements in the group, were trusts, and there were allegedly some partnerships and sub-partnerships in there as well. So the plaintiff also sought appointments of receivers to the assets of those trusts, and receivers to the assets of the various alleged partnerships in there as well. Now, just as a quick aside, some of the alleged sub-partnerships in the group were allegedly between the spouses of the three brothers and not the brothers themselves. And the challenge that the plaintiff bumped into in relation to this argument was similar to the challenge I referred to as well. Each of the spouses, spouse A, held these assets on trust pursuant to the terms of the spouse A trust deed. And so what that meant was that the assets were not held pursuant to a partnership between spouse A, spouse B, spouse C. I'm sure that makes sense, or at least I hope it does. And so this was the challenge that the plaintiff bumped into. So if we go back to the section 461 claim, essentially this is a claim about the breakdown of relationships, that there's been a breakdown of trust and confidence between people who are trying to run a business together, and you can get a similar wind-up in relation to a partnership. This is what the plaintiff is saying has happened here. Well, the court says, well, while there might be a breakdown in the relationship interpersonally between the three brothers and their relevant interests, what you have failed to show, plaintiff, is that each individual company of the however many companies there are ought to be wound up themselves on the just and equitable basis. So the court says it looks to us like each trustee company is doing its job as a trustee company. It's getting in some income, it's making some distributions, it's doing its job. And so there's no evidence before us that's going to assist us in concluding that company A, that is trustee of trust A, ought to be wound up. And so the court goes on to say it's not for the court to make its own inquiry in relation to trust A, trust B, company A, company B, company C, company D. It is for the plaintiff to make submissions about why each of these companies ought to be wound up on the just and equitable basis. These submissions haven't been made on a company by company basis, and so there's nothing for the court to do in relation to winding up each of these companies, and so the section 461 order had been made. And so now we come to the end of the judgment. Well, what the court says is this is frankly a fairly unsatisfactory conclusion, because what the court has concluded is there's been this complete breakdown of a relationship between the three brothers. And because of this litigation, because of the failed negotiations, because of the death of one of the brothers, we're never going to be able to get back to running this group the way it had previously been run by these three brothers informally. And so, yes, the court's concluded there has been this breakdown of relationships, but the breakdown of relationships doesn't support the orders the plaintiff's after. It's not a partnership to dissolve. No, we've made that finding. It's not a company or a bunch of companies that we can dissolve. I withdraw the word dissolve, that we can wind up pursuant to section 461. And so, despite the fact we find ourselves in a position of agreeing there's been a breakdown, there's nothing legal that can be done based on the plaintiff's application. And so there's this kind of half conclusion. And what the court does is, with great respect, something quite wise, is to invite further submissions from the parties about what should be done now. And I hope that discussion assisted you and wasn't too much of a cliffhanger. We'll have to find out what happens next. And I look forward to joining you again soon for another coffee and in respect of another case note. Cheers.